The question that the Supreme Court is trying to answer in Tanzin versus Tanvir is whether the Religious Freedom Restoration Act of 1993 permits suits seeking money damages against individual federal employees. The parties in this case are three immigrants who were practicing Muslims and the FBI agents who placed them on the no-fly list. The FBI agents asked these men to become confidential informants against other Muslims, but the men refused, saying that doing so would violate their religious beliefs. These men claimed that they were placed on the no-fly list in retaliation for their refusal. Though the FBI eventually removed these men from the no-fly list, Muhammad Tanvir and the others are suing for money damages under the Religious Freedom Restoration Act of 1993, which is sometimes called RFRA. RFRA enacts a very searching balancing test called strict scrutiny, which says that in order for a government action to succeed when it substantially burdens someone's free exercise of religion, that government action both has to serve a compelling government interest and also must be done in a way that is the least restrictive means of furthering that interest. The text of RFRA says that it allows for all appropriate relief. So that's the real question. That's why this is a case. If the very text of RFRA said money damages, I think this case would have been resolved a long time ago. The reason this is a Supreme Court case is that there's some ambiguity. RFRA says appropriate relief, but it doesn't say what the appropriate relief is. It's a significant question because while most cases under the Religious Freedom Restoration Act want the government to just stop illegal activity, there is a small number of RFRA cases where the plaintiffs do seek additional compensatory or even punitive damages because that's the only realistic remedy they have. Tanvir, for example, was a long-haul trucker, and he was unable to keep his job because he could not fly back from driving one-way loads. Tanzin frames their argument around the text, history, and precedent of RFRA to determine what appropriate relief means. It's definitely the case that RFRA does not explicitly grant money damages to be recovered against a government actor. Also, the courts have said in recent years that in the absence of an explicit grant of money damages in federal law, the court should not read money damages into federal statutes unnecessarily. Tanvir makes two arguments. The first is the decision in Franklin versus Gwinnett County, which was decided unanimously by the Supreme Court the year before RFRA was enacted. The Supreme Court in Franklin found that when civil rights statutes are ambiguous about whether money damages can be recovered against the government, the money damages do fall under the definition of appropriate relief. Tanvir's second argument is that under Section 1983 of the Civil Rights Act, which is the principal enforcement mechanism against officials who violate civil rights or constitutional rights, money damages against officials who violate the law have always applied. Tanzin versus Tanvir will have a big impact on future religious liberty cases, but it also gets at the issue of how do you resolve certain textual ambiguities. And I think that cuts across not just RFRA cases, but a wide variety of state and federal laws.